Hi everyone, it's Temi Siyanbade here, Houston-based attorney and host of Ask Temi Live, where we discuss the best ways to establish your business, protect your name, and keep your profits, right? You are dedicated to building your business and your brand, and I am dedicated to helping you protect them, right? I'm in the business of helping people protect what they create. And so today's question of the day is along those same lines. The question of the day is, what is an intent to use application for trademarks? Now, some of you are like, Temi, over our heads, but I really think you should know about this, okay? Now, this is my opinion. Let me give a couple of disclaimers. I've been starting to do this. You guys already know this, but just in case you're not sure, you're not my client until you become my client. Right now, I'm in teacher mode. This is Teacher Temi, and I'm sharing some information with you. Okay, so this is just some education. And so I'm going to give you some opinions based off of my experience, my education, just some thoughts and some insights to kind of help you understand what this application is and why I think it's important for you to know this. All right, I'm going to jump in. Now, I think that the intent to use application is probably the safest way to safeguard against waste and protection over your trademarks from copyrights. I'm just going to put that out there as we start off. That's the first thing. You're like, whoa, Temi, okay, come on, guns a-blazing. Yeah, I think that the intent to use application is pretty powerful. Now, before I talk about what it is, I will establish a few things. First and foremost, that there are two different types of trademark applications. There's the intent to use and there's in use already. And we're going to break those things down. But I really want you to understand the purpose behind trademarks. All right, so the main point behind trademarks is really twofold. It's protecting the competitive edge that people have invested in building, right? So if you're a business owner, if you're a brand builder, you've been out there working, you have connected with people, you have created products that people know, that they trust, that they like. You have invested time, money, and effort into having this competitive edge, right? That is seen in your brand. And the law, trademark law, is based on protecting that. Okay, it wants to protect that. So that's the first thing. The second thing it wants to protect, though, is it also wants to protect the consumers who have created consumers who have an expectation based off of your excellent work. What do I mean? Consumers, as they see particular brands, they start making associations. You think Coco Chanel, you think elegance, you think luxury, right? Nike, you think resilience, you think strength. These are things that people have or businesses have invested in. You think Coca-Cola, you think happiness, right? And consumers associate those same things. You see Coca-Cola, you are expecting a particular taste. You get Nikes, you're expecting a particular level of performance. You're shopping with Chanel, you're expecting a certain level of quality, right? And the law wants to protect consumers, and they don't want people to take advantage of consumers or of you by riding on the coattail of your work, okay? So because of that, there are these safeguards with regards to trademarks that really are put in place to stop copycats and to protect exclusivity. Okay? I want you to take this away. I want this to be one of the takeaways, is that trademarks are about businesses, brands, and trust. So that's all the fundamental stuff before we get into the two types of applications. So there are two types of trademark applications that you can have. One is called an in-use application. So the in-use application is for brand elements, right? So your logos, your names that you've already started using. You have proof that you've used it. Okay. And the proof is important when it comes to trust. Again, we want to make sure that you're using this in business. It's not just something that's all but you have a bona fide, you're truly using this. So in your in-use applications, right? Trademark, it means that you've already started using that name. You've already started selling things with your business name. You've already started selling things with that logo. You've already started selling things with that slogan. People have already started associating that. That's the in-use application. The in-use application is slightly cheaper than your intent to use application, and it's pretty straightforward. The beautiful thing about it is that if you're not familiar with like the stages of a trademark process, I will put a link in the description box below to kind of help you see that. But there's a process that all your trademark applications go through. The search is something your attorney or you should do up front, but then you submit your application. After you submit your application, it goes through something called the examining period, where there are different office actions and you're working with an examining attorney to kind of figure out what's next. And then it goes into something called publication, which is then publishing your mark, putting it out there for the world to see. Now, I say all of this to say all of those stages are the same for both your intent to use and your in-use application. But once you get through your publication stage, if you have no issues, 30 days later or 30 days once they give you notice, you're going to get your notice of registration and you will have a registered trademark because you have submitted proof when you submitted your application that you've already been using this in commerce, so they can trust that it is really about business. Okay? So it's faster process and you can pick up wherever you are. So again, if you've already been in business, you can go ahead and submit an in-use application. Now, the intent to use application is different. This is the reason why I like it. This one is if you plan on using it and you will have the proof of using it eventually. You can still submit an application before you've started using the name, the logo, the slogan. If you're about to, you can submit it, but you have to really be about it. You have to really be about to. And what do I mean by you really have to be about to? You have to have a bona fide intention to actually use this mark in commerce. Now, the difference is, let's say you're doing the application and you're doing the intent to use application. You're filling out the information, basically the same, but you're not submitting proof that you've been using this in commerce or using this in business because you haven't yet. It goes through the same process. It goes to the examining attorney. They review it. If there's no issues, it goes through publication. But then after publication, you're going to be required, like if your publication is successful, you'll get something called a notice of allowance, which means we will allow you to register on the official registry if you provide us with proof that you're using it. Now, the beautiful thing is that when it comes to the first in use, the who's been using the mark first, they're going to go back to the date that you filed your intent to use application and give you that date and say that's when your protection starts. Whereas your in-use one is a little bit different. You had to start using it and your protection is not going to go back to before you started using it. It's only going to go from when you filed that application. So if somebody copied you before you filed that application, there's no protection for you there. Okay. Now, the other thing about the intent to use application, the reason why I like it is because there are times where people go through the process and maybe they have gone through without help, or maybe somebody else submitted an application a week or two before them and they go through the trademark application and they run into roadblocks. And the issue is they might have already started investing in their branding. So they might have business cards. They might have a website. They might have a YouTube channel. They might have all these things that have that name, that have that logo, that have that slogan. But now that they're trying to register their trademark, they're running into issues. There was a coach, I remember, that she had made a big name for herself with a particular brand. And she decided that she wanted to finally register. And when it came time to register it, she ran into issues because they said, your name is too similar to somebody else's. And she spent years trying to battle this and was unable to successfully do that. So she had to totally rebrand, totally rebuild her platforms and retrain her consumers for this new brand. And she's not the only person to have to go through that. And that's one of the downsides, I think, to the in-use application, particularly if you're working by yourself and you don't have somebody to do a search for you. You can run into that place where you've invested time, money, and effort into something that you're not going to be able to register. But with the intent to use, let's say you go through the same process and you run into a roadblock similar to theirs. Luckily, you may not have already started to use this mark, so you can make the necessary adjustments. Now, here's the downside. It's a little bit more expensive, and here are where the costs come in. The filing fee for both applications is the same, but because you have this extra step of submitting your additional proof, Whenever you submit that additional proof, you're going to have to pay a fee. It's a smaller fee than the overall filing fee, but it is a fee that you have to keep in mind. And then if you're having an attorney work on it, there's probably going to be a fee associated with their extra work for it. Okay. Here's the beautiful thing. Let's say, so you go through the application and get through publication, and you're like, okay, I did the intent to use. Now I know that I'm not going to have any issues. I want to fully invest. I know this is what I want to do. I had a bona fide interest back then, and I still do. You will have 6 months to submit your proof. And that's 6 months from your notice of allowance, right? So that's not 6 months from the time you submitted the application, but from when they send you that notice. That's amazing. That gives you time to build your website, to print everything out, knowing that you're going to have a registered R next to it, like that circle R. Beautiful. But let's say you do that, and then all of a sudden you run into issues. You know, we had a pandemic. Maybe your manufacturers run into an issue. Something happens, and you have to delay. There is an opportunity to get an extension, a 6-month extension, but you have to pay for that. The beautiful thing is that you get 5 attempts, 5 different extensions, 5 different 6-month extensions for this. So you can wait up to 3 years before you submit the proof. But in each of these extensions, you still have to have a bona fide intent, a true intent to eventually, right, have this and use it in commerce. So that's the big difference. The thing is that you won't necessarily have to invest in all of the branding elements before you know whether or not you're going to be successful. And I think that's a huge amount of security to experience and enjoy with this particular type of application. All right. So those are the things that I want you to keep in mind. That's the difference. That's what an intent to use application is. And that's how it differs from an in-use application. Again, you are really allowing yourself to have that extra cushion of time and assurance to make sure that you're not going to have any issues before you overly invest in a brand that you might have issues with. Now, both applications work. I have folks, we do the search, we know what's in there, and we're able to be really successful. But I prefer the intent to use one in terms of really having overall protection. So that's basically it for today. That's all. If you found this to be helpful, let me know. I hope you've subscribed to this channel because we try and keep it quality here, and we want to make sure we continue to provide quality for you. Now, if you have any comments, any questions, leave them below. Additionally, if you want to follow us, you can. The handle is the same. It's TOS Legal. And the last thing is, you might be asking, okay, what are my next steps? I just learned all this information and I know I need help, but I want to get more assistance. 3 options for you. First option is to schedule a strategy session with me or another attorney, but let me talk about my process because you're here. It is the most customized, most personalized time that you can have with me to start off the process. Every person who wants to become a client, every business that wants to become a client has to start off with a legal strategy session in my firm. And so it's the first step and allows us to really understand where your business and your brand are and develop a strategy so that we know where we're trying to go. That might be an option for you. Now, if you're like, no, I need to wrap my mind around these concepts a little bit more, the other option, the thing I would recommend is we have a course called Elevate Your Business and Your Brand, Mastering Legal Strategies for Growth and Success. And that course is an in-depth look at all these different areas of the law and really understanding them when it comes to building your business and protecting your brand. So that might be a second option for you that you find valuable. But maybe you say that's not for you and that's not for you. The third thing that I would say, if you don't do number 1, if you don't do number 2, you should do number 3, and that is join our email list and get the free checklist. It is called Level Up Your Business and Your Brand, and it walks you through, or it explains to you the things that I do with my clients to make sure that they're protecting their businesses and their brands. All right, so those are some things that are available to you. The links for all of those things will be in the description box below. Again, I enjoy giving you this information. Feel free to connect with us, visit the website, and until next time, have an amazing day. All right, bye.